Hi, I'm Louisa Sijabat, a liquidator and bankruptcy trustee. So today's question is, what happens if someone who's going through bankruptcy becomes entitled to an inheritance during their bankruptcy? What happens if there's a testamentary trust involved in the will of the recently deceased? Alright, so two parts to this question. The first part is what normally happens to inheritances in a bankruptcy. The answer to this question is that inheritances are considered after acquired property that do go to the bankrupt estate. So in summary, the standard position is that for an inheritance that the bankrupt is entitled to receive or becomes entitled to receive during the period when they're an undischarged bankrupt, then those funds or that inheritance, those assets, those rights, they do go to the bankrupt estate. The second part to this question is what happens if there's a testamentary trust in the will of the recently deceased. Now, a testamentary trust is a trust used within a will, which is a type of discretionary trust. Now, with all discretionary trusts in bankruptcy, the trustee of that testamentary trust will have the discretion as to whether to distribute to the bankrupt or not. In the majority of cases, not surprisingly, the trustee will exercise their discretion not to distribute to the bankrupt. Now, it also depends on the exact terms or the specific testamentary trust. So obviously that document would need to be looked at to see what the bankrupt's rights, if any, are in relation to that particular trust. But what I've given you is the standard position for a very normal type of testamentary trust situation we see in a deceased estate.